Hello everyone, welcome to our seventh lecture on NCA constitutional law. So today we are going to take up three important topics, although these are very short topics, but in examination sometimes with another bigger topics, you might need to add on these topics. You have been asked to add on these topics like how you are going to interpret charter, then how you are going to apply, then whether charter rights can be overridden or not. So these three topics 17, 18, 19 we are going to cover today. So from here, part 4 of the NCA Constitutional Law exam syllabus starts. First is interpretation. How you read the provisions, how you understand the charter provision. So in this, you have to apply various interpretive rules, provisions, like purposive interpretation, then liberal interpretation. So we will be talking about these kind of thing. Then application, how you are going to apply the charter on various government as well as private actions. So in this we have important landmark cases like Eldridge versus British Columbia, which talks about hospital issues. Then we have transit related issue, Greater Vancouver Transportation Authority versus Canadian Federation of Students. Then override. Section 33 will cover this topic. So what are the situations, circumstances under which governments can override charter rights? So they can do something that is above charter rights. So that is justified. So this contain few limits that you cannot use this overridden section everywhere anytime. So there are few restrictions, there are few conditions. So like for this we have important case of Ford versus Quebec. So firstly, we'll start from topic number 17, interpretation of Canadian Charter of Rights and Freedom. What do we mean by word interpreting? So in simple terms, interpretation means you have a text before you, like charter provision before us. How we explain those, how we understand, make us understand as well as other people understand those provision, and what kind of meaning do we assign to that text, meaning assigned to a particular text. So this is interpretation. There are different ways that we'll be talking about later. So Bill of Rights remain in effect and offer protection beyond the charter. So we know that we have two things. Initially, some found the bill unsatisfactory due to its status as an ordinary statute. While the bill's effect is unclear, charter override inconsistencies. So wherever Bill of Rights had few drawbacks, loopholes, few inconsistencies, so then we brought Canadian Charter of Rights and Freedom, which overrid, which filled those gaps in the Bill of Rights. Then protection of civil liberties. So following the charter's adoption. So here we are understanding, we are interpreting the Charter of Rights and Freedom. So firstly, we discussed how and why we brought up the Charter of Rights and Freedom, because there were few inconsistencies in Bill of Rights. Bill of Rights was not fulfilling all the duties that were expected to fulfill for the Canadian people. Then Charter of Rights and Freedom protect the civil liberties. Following Charter's adoption, all Canadian jurisdictions except Quebec reviewed statutes for perceived Charter violations. Ultimately, courts enforced the Charter. While the Charter plays role, democracy, judicial independence are considered primary safeguard for civil liberties. So Charter plus democracy, judicial independence, all these three things together provides for civil liberties for people of Canada. Then expansion of judicial review. So before charter, courts could invalidate laws that were inconsistent with the constitution, with the issue related to federal provincial legislative power distribution. But when charter came, charter expanded the judicial review process. We discussed this whole topic, that how big, how wide judicial review is and how helpful it is for the people of Canada. So charter expanded this area of judicial review. Then charter's rights language is vague, empowering courts due to its vagueness. So what kind of judicial review has been expanded? So sometimes what happened, charter rights language is not that simple. Sometimes it's vague also. So what happens? Judges use their own interpretive mind, interpretive skill. So with that interpretation, they provide a defined meaning as per various rules of interpretation that we'll be discussing today. Then where does section 1 stand? So sometimes what happens, the civil liberties that we are talking about, the civil rights, the private rights of individual, fundamental rights, sometimes they conflict with other Canadian values. Then section 1 allows court to have a balance so that people's rights should not go against societal values. So wherever it is justified to interfere in someone's freedom, then section 1 has to brought in picture, and it will say that whether particular action of a government is reasonable, justified or not. Law limiting charter right is valid if it is demonstrably justified in a free and democratic society. This is exactly what section 1 says. So this is how we relate section 1 with the charter. So this is another interpretation. Then role of section 33. So section 33 permits parliament and legislature to override certain charter grantees. This override doesn't extend to specific charter sections. So that we'll be discussing later also. Charter of rights and freedom applies to provincial and federal governments. This we all know. It only protects people from government action against those rights that protected by charter. So what does the scope of charter? So charter only protect those rights that are mentioned specifically in the charter. So it does not apply to behavior of private citizens, private businesses. For that we have different human right codes, etc. But here we are only talking about those rights, the charter rights that are specifically protected by the charter. So this is how you have to interpret, this is how you have to apply charter. Section 1 provides reasonable limit section, this one. Then section 2 provides fundamental freedom, then 3 to 5 provide democratic right, 7 to 14 provide legal right, 15 provide equality right, 16 to 23 minority language right. So these are the few charter sections that are important. But as in how time passed by, the rights have evolved by including more things into them. So one right today is not just restricted to one area, like section 15 equality also protects today people against sexual orientation. So this is how we have been evolving. So rights under the charter are negative rights. It protects individual from state action, that state cannot do such and such thing in particular situation. Charter does not necessarily entitle a person to a positive right. So positive rights are the ones that just say, okay, you have this particular thing. But here you will see the language of charter says not, cannot discriminate. So it says that the charter majorly has negative rights. So government does not need to ensure you are treated equally. They have to act in a way that does not create inequality. So this not word create negative rights. So this is not something that we are reading right now that you have to directly apply in case scenarios. So this is for your understanding how you have to apply, how you have to interpret charter while writing your NCA examination. So these are just the theoretical conceptual things. Then dialogue with legislative branch. When a law is struck down, taken off, it often prompts legislative response, fostering a dialogue. They discuss things. So court decision initiate a dialogue rather than impose a veto. So what happens whenever a law is struck down? So usually rather than just going one clear-cut decision, just imposing a veto or a decision on legislation, court usually give decisions like, okay, this is unconstitutional, just look into it, take this back. So court often have a dialogue with the legislative branch. Then remedial discretion. Courts may suspend a declaration of invalidity to allow parliament time to amend laws. So this is what I said, that court sometimes tell parliament that okay, you have this time, you can amend this particular thing that is unconstitutional, that is going beyond the scope of charter. Criteria for such suspension include public danger, threats to rule of law, deprivation of benefits. So whenever court feels that some law that has been enacted by parliament is for the public danger or is threatening the rule of law, equality, or is depriving people of certain benefits, their fundamental right, then court go for this kind of discretions, remedial discretions, and this job assignment has to be done by legislative branch. So, but what happened in this situation when court says certain law to get struck down or amendment, then government within itself discusses that thing. Although there is no formal dialogue occur, but legislative body assess risk of new law. Upon interference by the courts, then they make changes accordingly. Then what about political questions? How does charter work in these kind of situations? So judges decide cases based on legality standard rather than personal preferences. So Canada lack doctrine of political question, unlike US. In US you will see so many cases, so many things that are politically influenced, but in Canada there is no such thing. So charter is free from political questions. There are generally two-step processes to charter analysis. Whenever we are analyzing any charter issue, firstly you will see that particular law that is in question, it infringe upon any charter right. So this is simple charter analysis. In examination, if you are getting a question related to a simple charter provision and you have to assess how you're going to interpret, how you're going to resolve that issue, firstly you will see that whether this law which is at issue in the case at hand infringes upon or worked against any charter right. Then second issue will be, is this law legislation enacted by particular such and such government could be justified under section 1 of the charter. So these are the two questions that you will have to analyze, answer in your charter issue question. So when you are directly getting an issue on a charter provision. So this is simple analysis. In examination, out of 4 or 5 questions, there are high chances that you get one question in which you have to assess an issue, then you have to see its justification under section 1. So courts take a broad, purposive and liberal approach. So these are the three interpretive tools: broad interpretation, purposive. The court will see the purpose, the aim, objective of the legislation. Then it will give it a liberal approach to interpret the charter. This happened in Law Society of Upper Canada versus Skypinker 1984. Then in BC Motor Vehicle Reference 1985, it must be capable of growth and development in order to address the changes within society. Charter interpretation should be generous rather than legalistic one, aiming at fulfilling the purpose of the guarantee and securing for individual the full benefit of charter protection. So this is important case in examination. You definitely have to refer this case whenever you are getting a question on interpretation. So it says that the interpretation usually has to be as general as possible so that maximum benefit could be given to people of particular charter's protection. There is no hierarchy of rules. No charter right can be used to nullify another. All charter rights are equal. So this is also another example of liberal, generous interpretation. Then what are the remedies? What happens? So whenever some charter is in issue, in R versus BM, what happened? Entire law was unconstitutional due to its religious purpose. So sovereigns allow court to remove specific provision while keeping rest of the law intact. But in this case, this sovereign's remedy was not helpful as entire whole complete law was unconstitutional. So sovereigns means you cut that part out of a particular legislation that is unconstitutional and you keep on giving the validity to that part that is constitutional. Reading down means when a particular law has different, more than one interpretation. One person, one judge is saying that okay, this means this, another is saying this means this. So you have to choose that interpretation that aligns with the charter. So that goes with the charter. You have to choose out of all those multiple interpretation that one. So reading down means you are just bringing down your conclusion, your interpretation to the one that relates to the charter. So interpretation of charter includes progressive interpretation. So progressive interpretation means a flexible interpretation that allows constitutional to adapt changes with time. Then generous interpretation means broad interpretation. You are promoting judicial activism. That means the judges can bring into their own discretion, own judicial minds in the decisions, like in Edward versus Attorney General Canada. The living tree metaphor was employed to advocate for a generous interpretation. They say constitution is a living tree. So constitution should be given a broad and liberal interpretation. It is a pathway to foster judicial activism. Such an interpretation could lead to more laws being invalidated than a narrow interpretation. So this is important. This is again another second case that you will have to add in your analysis when you are getting a question related to broad liberal interpretation. When we discuss this general interpretation, we are essentially referring to breadth of granted right, that you expand rights, their meaning as much as possible. Whenever we are judicially reviewing any charter, there is a second stage which involves the justification under section 1. So Oak's test, section 1 test for justification is very stringent, very strict. Peter Hawkes, whose textbook we follow, points out that there are potential issues with this approach. When you are broadly interpreting any rights, plus you are then trying to justify that under section 1, then sometimes what happens, the protection of rights shouldn't be protected. So Peter Hawke has criticized this approach, but courts have always said that we are not strictly following this thing. This Oakes test is part of a process. So courts can mitigate this by relaxing the Oakes test. Then, however, Hawke believes that providing a broad interpretation may result in an influx of cases. He argues that it's preferable to restrict the scope of charter right rather than relax the rule of justification. So Peter Hogg supports restrictive approach, but majorly all the courts of Canada, they go for generous liberal interpretation. So in examination, if you're getting a question, if they are asking your views, so it is always suggestive that you find a neutral analysis, a neutral conclusion. Never go for one side or one restrictive approach. Because again, as we read in the Edward versus AG Canada case, constitution is a living tree. With time, it definitely needs so many things to get adapted in itself. It needs a liberal, purposive interpretation if we want that people's right get protected. So purposive interpretation, as we read, ensure charter rights are interpreted liberally. Purpose means we have to focus on the aim objective. So charter rights, as per purposive interpretation, some charter rights are prioritized over other, but it does not mean that they are superior over the others. Then whenever there is a conflict between rights itself, then they can be resolved through section 1 justification. From where this interpretation comes? So from various case laws. This is the main basic source of interpretation. So we follow different case laws, we see what courts have said in those case laws, and then we apply in our interpretation. Then we sometimes follow the US Bill of Rights also. Then we have international covenants, conventions that influence charter interpretation. Then federal grounds take precedence when laws are challenged on both fronts. So charter came into force on 17th April 1982. Charter doesn't negate existing undeclared rights protected by common law statute. So if there are any undeclared rights, though that are protected by common law or any previous statutes, so charter doesn't negate those rights. So this was how we interpret. So again, the conclusion that comes from this whole topic was that a liberal, purposive, generous interpretation is what we follow under the Canadian law. So next is how we are going to apply Canadian Charter of Rights and Freedom. So section 32 of the Constitution Act outlines the application. So charter applies to Parliament. We know that Government of Canada, federal government concerning all matters within the authority of Parliament, including those related to Yukon Territory, Northwest Territory. Also, it applies to provinces. So, from section 32, we get to know that the Charter applies to whole of Canada. Exception for section 15. This application has one exception, that is under section 15 clause 1, which guarantee equality right shall not take effect until 3 years after coming into force of this section. So section 15's enforcement. So from 1982, after 3 years, section 15(1) had been kept away from application. So except this one particular section, for the initial 3 years, whole of charter applied to Canada. So to all federal governments, to all provincial governments. Next thing that comes into picture, that's the another issue, is whether corporations are included under charter benefits or not. So issue of whether corporations are entitled to benefit of rights under charter hinges on interpretation of language used in the charter. So we have to go by the language. So while the charter often use terms like everyone, anyone, any person, but it suggests individual. It's not always explicit. So we have to go by every provision, and in every single provision we have to see what's the language use. So whenever we have to see who can get benefit of rights under the charter, we have to use the language interpretation. So terms like everyone, anyone, any person are used interchangeably. Some rights like right to life and liberty may not be applicable to corporations due to the nature, because corporations are not any living entity, they are not individuals. But like section 24 of the charter, it provides remedies against breaches, applies to anyone, which include corporations as well. So where corporations are an entity, an individual party in some case, and we are talking about remedy. So in case of breaches, remedies are available to corporations. But again, which are impossible, which are impractical, those rights cannot be given to corporation, like right to life simply. So section 15 confer equality right on every individual. So every individual, directly we can see that from the wording, from the language interpretation of section 15, it exclude corporation. Citizenship is not always a requirement to invoke most charter right. Individuals need only be on a Canadian soil. Permanent resident status is relevant for certain rights like mobility right under section 6.2. So these are various different applications like how and where charter applies. Section 32 makes it clear that both federal and provincial government are bound by the charter. So any body exercising statutory authority, including municipality, administrative tribunal, so any kind of government authority is bound by the charter. They have the burden of protecting people's right. Then private actions. This I told you earlier as well, that rights granted by charter primarily act as restriction on governmental powers over individual. So charter typically does not regulate relation between private parties. So for those we have another different acts, legislations, like for contracts we have contract acts, so things like that. Until and unless in a particular scenario there is some government presence, some statutory involvement, charter typically does not apply. So for this we have various cases that we'll be looking into. Then extraterritorial application. Foreign governments are not bound by charter. So actions that are taken outside Canada are not charter breaches. But there are few exceptions where Canada is in breach of any international obligation. So for this we have important cases like in Canada versus Khadr 2008. Omar Khadr, he was a Canadian citizen. He was captured by American forces in Afghanistan and was subsequently detained at Guantanamo Bay facing charges of murder. So Khader applied to Federal Code of Canada under Section 24, which is for the remedies, seeking disclosure of records of interview that were conducted with him in 2003 by Canadian Security Intelligence Service and provided to US. So Supreme Court of Canada held that Khader was entitled. He had right to disclosure of those records being a Canadian citizen. No matter now he is on a foreign land, but so the trial had taken place in Canada. Khader would have been entitled to Stinchcombe right of full disclosure under Section 7, while the case of HAPE. So it depends upon case to case. What kind of situation is this? How serious is the matter? What kind of fundamental rights are in question? Like here, Section 7, which is important charter right. So that is why we allow disclosure of evidence. He had right for that. But there was another case, HAPE case. He had previously held that charter did not have extraterritorial effect. The opinion of HAPE suggested an exception in cases where Canada was in breach of international obligation. In Khader case, court determined the process of Guantanamo Bay, which was contrary to 1949 Geneva Convention to which Canada was a party. HAPE ruling did not apply, charter required extraterritorial effect. Although neither interviews nor handling of record was found to be a breach of charter, but ultimate result was that Khader was entitled to Section 24(1) remedy of disclosure, being a Canadian citizen. So this is important. You have to analyze from case to case basis that if some international convention treaty is involved, whether we are still party to that treaty. If we are, then we have to go by those rights, those rules and regulations, no matter wherever the Canadian citizen is. Then does charter applies to code? So application of code, definitely yes, 100% charter applies to code. So in R versus Rahe 1987, Supreme Court of Canada addressed whether a criminal court had violated defendant's Section 11B right to be tried within a reasonable time. So case involved multiple adjournment over 11 months, so delay. Supreme Court of Canada emphasized that the courts as custodians of principles enshrined in the Charter must be subject to Charter scrutiny when it comes to administration of duties, administration of justice. So this important decision in R versus Rahe was again affirmed, accepted in another case of BC Government Employee Union versus BC, where principles laid down in this case were upheld. So this case confirmed that courts themselves are accountable under charter. So courts have to, in order to provide timely, fair administration of justice, work in alignment, in peace with charter rights and protection. So this is important. Then common law. So when it comes to Canadian law, Charter of Rights and Freedom does not directly apply to common law, especially where there is no government actor involved. However, Charter does have indirect effect on common law, particularly through the consideration of Charter values, which were used in development and interpretation of common law principle. So we only follow in an indirect manner while interpreting the principles, but without interpretation or any kind of development, straightforward directly under the provisions, we do not apply charter on common law. There was a case of Hill versus Church of Scientology where a government official brought an action against the church for defamation in his personal capacity rather than as a representative of government. So this is a personal case of defamation, not as part of government officer. Court determined that because the action was brought by a private party to vindicate private reputation, personal reputation, here charter could not be applied. So defamation, a common law matter. So here we are not applying charter. Even though charter did not have direct applicability, courts still found it necessary to consider whether the common law principle involved were consistent with charter value. So it will depend upon case to case. Like there was another case of Eldridge versus British Columbia. This is one of the most important cases directly mentioned in syllabus. So there were two different charter application issues though that were discussed in this case. Firstly, identifying the precise source of alleged violation of Section 15(1). Secondly, whether charter applies to those entities. So regarding the source of the alleged charter violation, it was established that the provincial legislation was involved. So this was a case of provincial law. There are two ways in which we can do so. First, by legislation being found unconstitutional because it violated charter right and it is not saved under section 1. Secondly, by charter being infringed by the action of delegated decision maker in applying the legislation. So who, in two ways we can see that particular violation is coming from. Firstly, the act that has been enacted by provincial government, it directly violates some kind of charter right which is not saved by section 1. Secondly, we can also see the acts that are performed by a particular decision maker, authority, any officer under those legislations, if though that person's actions are not aligning with the charter, then also we can say that okay, this is a valid application of charter protection. Here we have to see whether this particular legislation or whether this particular government actors actions are not aligning with the charter or they are infringing some charter rights. So in the case at hand, this Eldridge case, the question arises whether the alleged breach of section 15(1) arise from impugned legislation itself or from the action of the person who was the main decision making authority as per this law. It's necessary to decide where the impugned legislation can be interpreted in conformity with the charter. So failure to provide sign language. So there was a medical setting and few people needed in that hospital kind of setting sign language interpretation. So section 15(1)'s provisions are definitely getting violated here. So the Medical and Healthcare Services Act, this was in question. Legislation simply does not prohibit Medical Service Commission from determining the sign language interpretation as medically required service and hence a benefit under that. So this was the main issue. There was a particular Medical Care Services Act in which nowhere it was mentioned that for the people who require sign language interpretation, who cannot speak, so sign language interpretation is a medical requirement or a benefit. So it's clarified that failure to provide expressly for sign language interpretation does not violate section 15 of the charter directly. So act delegate the power to make determination of which services. So this act does not talk about, neither it says okay we are not providing nor it saying we are providing. So this act, what it did, it has assigned this power to a particular subordinate authority, to particular group of people to decide which services could be qualified as benefits under the act, which people as a matter of right can ask to get. So, and it's the decision of the authority that is constitutional suspect, not the statute. So in this case, the act itself is not the source of issue. Here, the decision-making authorities' actions are the main source of issues. So regarding the application of charter to Medical Service Commission and hospital, it is established that while hospitals may be autonomous in their day-to-day operation, they act as agents of the government in providing particular services set out in the act. So insofar hospitals carry out specific government objective, if any hospital, no matter it is a privately owned, but it is following some rules and regulations, following some guidelines, objectives that are set by a particular government, like in this case by a provincial government, they have to follow the charter, because whenever you are doing something that government has asked to do, so no matter you are some subordinate authority, some private authority who is working on behalf of government or some commission or some legislation, you have to follow charter. So legislator cannot evade its obligation under section 15(1) to provide medical services without discrimination by appointing hospital to carry out that objective. Hospital must conform with charter in providing these services. So in examination, you might get a question directly like in true false form or simply short answer whether charter applies on hospitals or not. So you have to mention this case. And here in conclusion, again, you can mention that if there is no government legislation, no government objective involved, no government guidelines involved to follow, then there are chances that charter could not be applied. But generally, whenever some specific government objective has to be carried by a particular hospital, then you cannot take that particular thing from out of charter. So hospitals must follow, must conform with the charter in providing medical services. So this was what happened in this case. So this is a landmark case. That is why I'm focusing on this, because in examination there are high chances that you might get something related like this. Then there is another case of Greater Vancouver Transportation Authority versus Canadian Federation of Students 2009. So issue here was whether charter applies to entities like BC Transit and Translink. So charter applies not only to parliament, legislature, government themselves, but to all matters that are within these government's authority. So this is important. So principles that were related to interpretation of charter to entity were summarized beautifully in the previous case of Aldrich. There are two bases for the charter to apply to an entity. Firstly, it should be a government entity for the purpose of Section 32 application. Entity specific activity can be ascribed to the government. So if the entity is found to be government by its nature or by substantial government control or by any regulation that, like we saw in the Aldrich case, that there were few objectives assigned by the government to a particular authority to get fulfilled. So then for all those activities, we have to apply charter. If the entity is not itself government but is performing government activities, so only those activities deemed governmental in nature will be subject to charter. In the case discussed, both BC Transit and Translink are considered government within the meaning of Section 32 because BC Transit, Translink are governed by legislation that is a government legislation. Therefore, it's unnecessary to inquire into the nature of particular activities that they do. Everything they do is subject to charter. So this conclusion aligns with the principle that government should not be able to evade its charter obligation by conferring its power to another entity. So no matter government itself is not taking a particular action and is assigning some other authority to do something on its behalf, no matter a particular thing, designation, authority is acting as an agent of government. No matter you are an agent of government, till the time you are under the scope of government authority, you have to follow charter right. So these were the first two topics, interpretation, application. So firstly, we saw how we are going to understand the charter. Then we saw how we are going to apply, where we are going to apply, what are the issues. Like first thing, whether a particular thing comes under section 32, whether any particular law that is in question is against any charter right, or thirdly, whether it is being protected by section 1 Oakes test or not. So now last topic 19, override of rights. So in which circumstances parliament or provincial legislature may directly explicitly override any charter right, or what are the charter rights which cannot be overridden. So section 32 is the main provision from the Constitution Act 1982 that we are going to refer for this particular topic. So now firstly let's read all the 5 subsections. Subsection 1, Parliament, federal government, legislature of province, provincial government, may explicitly state, it means there should be no confusion, directly clearly say in an act of parliament or of the legislature as applicable, that particular act or provision shall operate, notwithstanding a provision included in section 2 or 725. So what are the rights that can be overridden by parliament or provincial legislature by a particular act? So section 2, 7 to 15, only these, no other right. An act or provision of act in respect to which declaration made under this section is in effect shall have such operation as would have but for the provision of this charter referred to in declaration. Declaration made under subsection 1 shall cease to have effect 5 years after it comes into force or on such earlier date as may be specified. So whenever any parliament authority or provincial authority make any law which is against section 2 or 725, sometimes date is mentioned that okay, till this time this will apply, but maximum time is 5 years. After that, that particular provision will stand ineffective, but they may reenact such declaration. Subsection 3 applies in respect of a reenactment made under subsection 4, so this one. So how this whole thing works? So as we read in previous slide, section 33 allow parliament to override, parliament or any provincial government for that matter, to override section 2 or 7 to 15 of the charter. Parliament or any provincial authorities empowered to enact a statute that limits one or more rights or freedom granted by section 2 or 715. If the override didn't exist, such a statute could only be valid if it came within section 1 charter. Section 33 till date has been used 4 times. Once in Quebec in response to Supreme Court of Canada decision in Ford, Quebec legislature banned the use of languages other than French for commercial signs and used section 33. Then once in Yukon Territory in a statute that was never brought into force, so that was invalidated. Then Saskatchewan used it to protect a back to work law that was contrary to grantee of freedom of association. It was later held that statute did not offend the charter, so it didn't need to use section 33. It was valid in itself. Then Alberta once used this section to protect law that stipulated that marriage could not be between same-sex people. So 710 provinces and 23 territories never used power to override, nor the federal government ever. So we know that the rights that could be overridden are only under section 2 and 725, so legal and fundamental freedoms. But in examination, if you're getting a case scenario in which one of these rights are mentioned and the question is related to issue of overridden, then directly in the rules, firstly you have to mention that as per section 33, only these particular rights can be overridden. The right that is in our case at hand, that is in our question, and if that right is one of these, like democratic mobility, language, enforcement, or sexual equality, then you have to mention that this particular section does not come under the purview of section 33. Then in analysis, you will use various case law, you will relate the fact to these sections. So this is how you're going to answer your question. In order for section 33 to be effective, must specify the charter provision to be overridden, can refer to more than one or even all of them. So any one particular enactment legislation that goes for overriding should include one section or all of them. So there is no limit that one time you can only override one right. Then section 33 provides 5-year limit. This we already talked about. Then specificity of declaration. It is clearly mentioned in the very first line that explicitly meansly. What does this mean? Express declaration, manner and form requirement. So declaration must be in the statute itself, can be added to a pre-existing one by amendment. Declaration must be specific as to the charter right to be overridden, that which charter right you are overriding. In Ford case, the rights referred to the provision of section 2 and 7 to 15, this reference was held to be sufficient. So specifically this line was mentioned in the Quebec one. Rights cannot be taken away retroactively. Like previous right, active effect does not apply. So once you are declaring that particular such and such rights are going to be overridden, then it will apply for the future scenarios, not for the previous retrospective ones. The rule of law required that a person be aware of the constitutional rights at the time of acting. Now, the main thing. So you must be thinking that okay, if we have section 33 that anyone can use this and anyone can take away our rights from us, the answer is a big no. Till the time we have this concept of judicial review under Canadian justice system, you need not worry. So judicial review is here to protect you. So section 33 will be held invalid by the courts if it fails to satisfy the conditions mentioned under section 33. So first thing, it must be specific as to statute that is exempted, rights that are overridden, and there should be no retroeffective active effect. So if there is one of these things, then court can say, okay, this decision, this particular declaration made by any government related to any right is invalid. We are not going to let it in effect. Evaluation of section 33. So many argue that section 33 is incompatible with constitutionally granted right. So putting Quebec aside, the power to override has rarely been used by Canadian governments. This is due in part to political resistance from opposite parties because no party would like to use this overriding thing and be in people's eye as a negative government. So due to this political resistance also, it has been rarely used in the Canadian history. So there is a question of who should determine question of right. So unelected judges or democratically elected official. The power to override is uniquely Canadian invention. So you won't see this in any other jurisdiction majorly. So the important legislation that in examination you have to refer while you are answering a question on overriding power, it is Ford versus Quebec, Attorney General 1988 case. So paragraph 23 to 36 are important. Supreme Court of Canada held that a law banning the use of language other than French in commercial sign was an infringement of charter right to freedom of expression. Quebec, the only province to oppose the creation of charter, wanted to create an autonomic, their own individual separate rule that would all their legislation operate notwithstanding the charter. So Quebec wanted to make this particular law. So issue was whether legislation overriding multiple section of charter is acceptable, whether all encompassing use the override is valid here, whether a retrospective override clause is acceptable. Because here Quebec was trying to bring this in retrospective effect. Supreme Court of Canada held that Section 33 declaration is sufficiently expressed if it refers to number of sections. Firstly, you cannot say that we are using French language. You have to mention particular sections that okay, through this legislation, Quebec government is trying to bring down, trying to override this particular section because this is the basic requirement of Section 33 paragraph of the charter which contain the provision or provisions to be overridden. So number one requirement, you have to be clear with regard to particular number of section that okay, Quebec government is going to override section 2. For next 5 years, we won't be following section 2 in our province. So this is how you have to follow section 33. Requirement suggested by the Court of Appeal of an apparent link or relationship between overriding act and the granted right of freedom to be overridden seems to be substantive ground of rejection, which is unacceptable. Supreme Court of Canada held that an ominous reference to right was sufficient, not reasonable to require a reference that was particular to the statute containing declaration because legislative body might not be in a position to judge with any degree of certainty what provision of the charter might be successfully invoked. So Supreme Court here followed a liberal approach and said that okay, sometimes what happens when a government legislatures enact law, it could be possible that they don't have any particular detailed legislative law knowledge, legal knowledge basically. So they might not be sure that okay, for this particular action, what all charter right needs to be invoked. So Supreme Court of Canada held normal presumption against retroactively should be applied to the language of Section 33. Sections should be construed as permitting prospective derogation only. So this is what clearly Supreme Court of Canada stated. So court held that Quebec could enact this blanket legislation immunizing all their legislation from charter scrutiny under Section 33 need express language. So here what court said that they need express language. They cannot just go by the confusing terms. However, Quebec court could not do this retroactively. They can do so, they can bring such legislation if they want, but firstly they have to change the language, they have to expressly mention what all rights they are going to override. Secondly, if they want to do so, they cannot do this retroactively, they have to follow it prospectively for the future times. So despite ease with section 33 may be invoked, use of override would be politically crippling for most governments. So it would be politically very dangerous for any government to follow, because nobody would like people, no matter wherever in whichever province they are living, they would never be happy with the government they have chosen in a democratic nation if that government is taking away any of their fundamental freedom or legal rights mentioned in section 2, 7 to 15. So that is why this overridden provision is rarely used. So mechanism is simple, but reality political cost of invoking will keep governments in check. So this is important line that I have been telling you. So this was all about our today's lecture. Thank you and good luck.